Good afternoon. Today, a Cuyahoga County grand jury handed up an indictment against former Ohio Speaker of the House Larry Householder on several state charges related to his misuse of campaign money to pay for his criminal defense against federal criminal charges. Also, for related ethics violations and reporting requirements. These charges result from our ongoing OCIC task force investigation. Just a few weeks ago, I announced the first fruits of that task force's work. The indictment of former First Energy executives Chuck Jones and Michael Dowling, as well as former PUCO Chairman Sam Randazzo, and two business entities associated with the House Bill 6 corruption scandal. Today's charges, which are state charges against Larry Householder, are the next step of accountability. Since Mr. Householder is already serving a 20-year federal sentence, you might ask, why would we bring additional charges at this point? The answer is simple. State law provides for a bar or a prohibition on ever holding public office again, and the federal law doesn't have that provision. You'll hear more about the details of the charges and the potential penalties in just a moment from Deputy Attorney General Carol O'Brien. Larry Householder served in the Ohio House as Speaker from 2001 to 2004. He left under a cloud of an FBI investigation that, to be fair, ended in 2006 without charges. Although he spent more than a decade out of the General Assembly, his surprise return to the legislature and his subsequent election as Speaker of the House earned him the nickname Comeback Kid. The corruption that followed, what we now know as the House Bill 6 scandal, is still being unraveled. Mr. Householder has appealed his federal conviction, of course, and should the conviction be overturned on appeal, he might well try for a third bite at the apple, a possibility that legislators have raised in private with me, citing deep concern. The crimes alleged in this indictment are separate from those that were addressed in the federal trial and stem from different, although related, actions. Even if Mr. Householder's federal appeal is successful, a conviction on state charges in state court for theft in office means the comeback kid will never come back to the General Assembly. The public interest demands the punishment of the conduct and the deterrence of others who might be tempted to the same sort of wrongdoing. Yes, we're sending a message. An additional question, why now? Well, that's because the statute of limitations on one of the cases is nearly ready to run, and we could only bring state charges before April 9th. I would like to thank Cuyahoga County Prosecutor Michael O'Malley, a career prosecutor with justice in his heart, who allowed us to seek these charges in Cuyahoga County. I'm also thankful for the members of the grand jury who, when presented with the task force's investigation, returned a true bill indictment. Ohioans in every county know that public corruption is wrong. Finally, as with the first time we announced indictments, we will not be taking questions today. The ongoing task force operations are confidential as a matter of law, and our arguments will be made in court. The OCIC task force continues its work. I cannot now predict whether any additional charges will be forthcoming because that's the nature of an investigation, uncovering what happened and who did it. An ethical prosecutor does not start by selecting a defendant or choosing a charge, but rather tries to investigate a crime to uncover what happened. Only then are charges considered. Only then can a defendant be fairly identified. Today may be the last time I speak to you about this task force's work, but perhaps not. It's simply impossible to tell where the road ahead leads. Now I'd like to turn this over for detailed explanation to Deputy Attorney General Carol O'Brien. She's a career prosecutor, a former elected county prosecutor, and she's leading this task force. She'll explain the details of this new indictment.
Good afternoon, everyone. Thank you for the opportunity to discuss the indictment of Larry Householder. Thank you, Attorney General Yost, Summit County Prosecutor Elliot Kulkovich, former Summit County Prosecutor Sherry Bevan Walsh, Cuyahoga County Prosecutor Mike O'Malley, and Summit County Sheriff Candy Fothery for your support of the investigation and the resources you have committed to the task force. It is only through the hard work of the task force team that we are here today. Mr. Householder stands charged with 10 felony counts that arise from his time as an elected official beginning in April of 2017 through September of 2022. Mr. Householder is charged with stealing more than $750,000 from his campaign account, Friends of Larry Householder. The money Mr. Householder stole from his campaign account was used to pay for his criminal defense. This activity accounts for 5 of the 10 counts in the indictment. Mr. Householder had checks written and authorized wire transfers for money from his campaign account to be paid to his Cleveland defense attorneys. The evidence will demonstrate that Mr. Householder was aware that he did not have the authority to pay for his criminal defense with his money from his supporters in his campaign account. Count 5 in the indictment, theft in office, while not the highest level felony charged, may be the most significant of the counts and is found in Chapter 2921 of the Ohio Revised Code. It's titled Offenses Against Justice and Public Administration, which deals with acts tending to subvert the processes of democratic government, crimes which hamper law enforcement, and the administration of justice, conflict of interests, and other offenses of public officials. Theft in office provides that no public official shall commit any theft offense when the property or services involved is part of a political campaign fund. If convicted, the court shall require the public official, in this instance Mr. Householder, to make restitution in addition to the term of imprisonment and any fine imposed. But arguably, the most important sanction required by this section can be found in C1. A public official who is found guilty of theft in office is forever disqualified from holding any public office, employment, or position of trust in this state. The 5 counts of tampering with records pertain to Mr. Householder's Joint Legislative Ethics Committee, or JLEC, financial disclosure filings for calendar years 2017, 2018, 2019, and 2021. The financial disclosure statement requires filers to disclose information regarding their personal finances and fiduciary relationships. In each of these annual filings, Mr. Householder omitted information in a number of required sections. Each of these omissions is a separate and distinct basis for a verdict of tampering with records belonging to a government agency. And each of these omissions were relevant to the issue of Mr. Householder's potential and/or actual conflicts and acted to conceal important and relevant information, including business relationships, pending lawsuits, and the status of Mr. Householder's financial health. During the Assistant U.S. Attorney's skillful cross-examination of Mr. Householder in the federal trial, he admitted that he did not report significant debts on 2 credit cards going back to at least 2016, as well as gifts from lobbyists and significant loans from individuals. Additionally, Mr. Householder neglected to report the legal fees he owed as a result of lawsuits filed against him and unreported businesses with which he is connected. These omissions are much more than simple mistakes. The sheer breadth and continuity of these omissions show a concerted effort by Mr. Householder to hide his obligations, to hide his personal finances, and his business connections. Attorney General Yost answered the question that many of you have. Why now? And for some of you, the question was broader. Why bother? He's been sentenced to 20 years in federal prison. The answer to this question is simple also. He committed crimes against the state of Ohio. He violated his oath of office. He committed offenses against justice and public administration. and he violated the trust of the people who financially supported his campaign and the trust of the people of Ohio. It gives me no pleasure to bring these charges against a former state representative, but my oath and duty as an attorney is to follow the law wherever it leads, regardless of the defendant's status. Thank you.